So you have a story to tell us today.
Yeah, it's an update to cakehole law.
Cakehole law.
Yeah,
What is cakehole law?
that's my website. It's the title of my website, Cakehole Law. The Canadian criminal and justice system and how to defend yourself.
How to defend yourself
Yes. This,
without a lawyer.
Yes, especially without a lawyer. Because in the courts of British Columbia, a lawyer is your worst enemy.
Worst enemy.
Appearance in those courts, that lawyer is your worst enemy. His only purpose is to obtain a contract between you and the courts to abide by their illegal and improper rules.
Illegal and improper rules meaning they're made for lawyers?
Yes, these are rules that are made to cover up certain criminal conspiracies in those courts, to deprive the individuals before those courts of their legal and constitutional rights. There's a criminal conspiracy by the judges of these courts, the Law Society of British Columbia, the Attorney General of British Columbia, and all the defense attorneys who practice this cakehole law in those courts. The real law of Canada exists in the criminal code.
Is not the criminal code the basis of their law?
No, the basis of the criminal law in Canada is common law, English common law. But the English common law contained a number of horrendous
Antiquities?
not antiquities, activities by judges, lawyers, and attorney generals of provinces. The statute law that we have in the criminal code was enacted in most cases primarily to remedy the mischief created by these judges and these attorney generals and these lawyers. It was
Created for self-interest and to disempower the people.
in some cases, but in other cases, it was created and promulgated to protect us from the judge, from the attorney generals, and from the very lawyers who are supposed to be defending us in these courts.
Oh, I see. They're actually for the people.
Yes.
Common law.
There were some people in the aristocracy of England a long time ago, some of the very few honest, real people there. King William was one of them. In 1837, he made a number of statutes to protect us from the judges who were railroading us in these courts. These statutes were placed there to remedy it and protect us from these judges. Specifically, one of the statutes was that the courts of Canada were to make rules of court for the pleading, practice, and procedure in the courts.
Of self-counsel.
Yes. The judges of those courts preferred cakehole law. That's the law of judges. The law issues from their cakehole. That's what they claim. But in Canada, the law issues from the criminal code and other acts of parliament. The criminal law of Canada is reserved entirely to parliament. But the provinces are allowed to administer that criminal law. But the judges of these courts in British Columbia have interpreted the law to mean the exact opposite of what it says. As an example, one of the statutes enacted in the 1800s to protect us was the progenitor of Section 540 of the Criminal Code today. It states explicitly where the evidence is taken in a courtroom, in a trial, it shall be taken, the judge shall cause the evidence of the witnesses to be taken under oath in the presence of the accused. And further, he shall cause a legible record of the evidence to be made.
Of the proceedings.
It shall be in legible writing on one side only of a piece of paper. That was the progenitor of the transcript in the courts today. When they introduced the stenographers into courtrooms to make it easier for the judge, because there was a hell of a lot of writing for the judge.
The judge did the writing back then.
Yeah, in the middle of a trial. So what they did was introduce these stenographers, and then they modified Section 540, where the evidence is taken by a stenographer, it shall be transcribed. and accompanied by a certificate. And when they introduced sound recording apparatus in the mid-50s, they modified it further to state as well that if it's taken by a sound recording apparatus, it shall be transcribed. Now, these judges of these courts interpreted those sections to mean that they had some kind of discretion as to whether they should make the record of proceedings or not. The law was promulgated to remedy that very discretion that these judges had assumed. It was to make it mandatory for them to produce this record so that when a person is convicted, there is a record of proceedings on which an appeal can be heard.
And without an appeal, one can go no further.
What these judges have done have refused to make the record of proceedings. And when an accused goes to a court after being convicted, they say, where's the record, where is the transcript? And most poor ignorant accused haven't a clue what to do. Says, we don't know, and they say, appeal dismissed. The rich don't have to worry about it, but the poor are railroaded. These judges have been
You
building.
mean you can buy the transcripts for a price?
Yes, but there's nowhere in the criminal code or any other act of parliament which states that the accused must supply to anybody, or that he must buy them from anybody. Indeed, the criminal code states explicitly in section 603, where the accused has been ordered to stand trial or at his trial, he is allowed to inspect the record of proceedings, amongst other things. And that extends to after the trial. He may inspect the record of proceedings, the transcript that is supposed to be made by the judges, which these judges refuse to make.
From the sound recording?
Or from the stenographers. I did a challenge into the Court of Appeal on this very matter. It had to do with a court reporter at my trial where I defended myself. The fact that the court reporter is required by law to make the transcript at the direction of the judge. Now, the court reporters of British Columbia never made any transcripts at any request. If you requested a transcript, they would charge you thousands of dollars. They were employed by the Attorney General of British Columbia as court stenographers, and on top of that, they were charging the accused thousands of dollars to make the transcripts.
Thousands meaning how much per page, per word?
It's $8 a page.
One side?
And yes, and in most trials that adds up to about $10,000 for the transcripts, for the illegal requirements of the appeal courts. Now,
Which in effect short circuit any appeal of someone without that kind of money.
yes, if you're poor and ignorant, you don't get the appeal. But one of the upshots was, after my arguments in the Court of Appeal on this,
May I ask you this, how did you get the transcripts to get an appeal on the very rule of law about the transcripts?
I did a constitutional challenge in the Court of Appeal. I started off in the Supreme Court, did a constitutional challenge in the Court of Appeal on the very fact that no transcripts had been made for the trial, and they were required to be made by the judge. Also, Section 530 of the Criminal Code was included in there because that's a mandatory command for the judge to and the Attorney General to make these transcripts. They're required by law to be in the record of proceedings. The Court of Appeal decided that I could argue my ground of appeal, that the verdict of the jury was unreasonable. But there were no transcripts. I could not argue the appeal without transcripts. Therefore, I was being denied my appeal properly, so they decided that they would order the transcripts and provide me with the transcripts for the appeal, and they charged it to the Attorney General. Then my...
Is that a first time, you think, in
yes.
Canada?
It was one of the first times. It was a precedent, but the other courts are resisting following it. Now, the entire proceeding...
What date was this? When did this occur?
It's on my website. What was it, 1998? beginning in 1999. I had my final appeal heard in the Court of Appeal. I overturned my conviction. Court of Appeal overturned the conviction, and instead of ordering trial, which is the standard procedure, they stated that they were going to give me a substituted verdict of acquittal. Now, that's fairly rare. It's usually a new trial that's ordered, but they decided from the evidence of the transcripts that the jury's verdict was unreasonable. One of the reasons it was unreasonable is that the police officer, Corporal Melky of the RCMP, had committed perjury at the trial.
Well, on the stand.
Yes, it was blatant perjury. The judge had not cautioned the jury about this perjury. The Crown had introduced this perjury. When I finally got my appeal granted, my conviction overturned, my record cleaned up, I then filed criminal charges against this Corporal Melky for perjury. Now, the
Again, first, I would take it.
Oh yes, they were claiming before then that only police can file charges, which is utter nonsense. Anybody may file criminal charges against any cop, judge, Prime Minister of Canada if they want. But the fact is that the JPs are instructed, the Justices of the Peace, who are the ones who take the informations, they are instructed by the Attorney General not to issue process on any private informations. The police are simply, how would you say it, fast-tracked through. They're always approved, no matter what the charge is. Now, there is a procedure. Before now, it was not lawful for us to take it any further. But because of another challenge I did in the Supreme Court and the Court of Appeal, mandamus has been brought back into the courts of British Columbia.
Mandamus, what is this?
In 1972, the Supreme Court of British Columbia passed a rule of court, Rule 63. This rule stated that mandamus no longer be applied for. Mandamus is Latin for an ancient procedure that was placed in the law by, I'm not quite sure who it was a king. It was to protect us, the people, again, from these crooked judges. It's in Latin it means we command. The higher court commands the lower court to do something that it is required by law to do. If the lower court refuses to issue process on a criminal charge against, say, a police officer, where it is a blatant prima facie case against the police officer, then that JP is not exercising a discretion. He is exceeding his jurisdiction by stating that there is some absolute defense for the police officer, therefore he will not issue process. But they are instructed, these JPs, from the Attorney General's office not to issue process. Now, the only alternative was to go for mandamus in the Supreme Court, to order them to issue process. The Supreme Court had made a rule of court abolishing mandamus. My first two sojourns into the Supreme Court on mandamus, I had to fight my way in. The clerks had refused to take the application. I had to threaten to charge obstructing justice if they refused to do so.
Interesting.
And they had a long conference with the Crown Office, the Attorney General, and decided that they would at least allow me into the court. And at the first two appearances, first Judge Owen Flood ruled that mandamus has been abolished. I have no jurisdiction to hear you. Therefore, I dismiss your application. The second time, the second judge stated, I quote her, Judge Quiano, Q-U-I-A-N-O, stated, mandamus has been abolished. Mr. Rusk is right. Mr. Rusk is a troubleshooter for the Attorney General. He acts as Crown Counsel in cases like mine. And she said, there is no jurisdiction. Mandamus has been abolished. Mr. Rusk is right. There is no jurisdiction. Well, I appealed both of those to the Court of Appeal. on a little known section of the criminal code that says I have an absolute right of appeal
Which
on the
section is
mandamus. This is what the Supreme Court had been hiding from us all this time.
But it's there in the criminal code?
Yes.
Which section is that? Do you
It's
recall?
section 7, I don't have my code with me, it's 778. Well, anyway, section 774 states that the ordinary remedies, which includes mandamus, applies to this part in criminal proceedings. Now, this was an attempt by the Supreme Court to lock the very door that mandamus was created to open. Without mandamus, there is no alternative from what a justice of the peace does in her court. With mandamus, she can be compelled to issue process. Well, in the case of Corporal Melky, I went to the Supreme Court, again, after I had done a constitutional challenge in the Court of Appeal on the very Rule 63. I presented enough evidence and enough argument that those courts realized that Rule 63 was essentially a criminal conspiracy to prevent we, the people, from gaining access to the Supreme Court, to gain these remedies. After I proved the third appearance in the Supreme Court, Justice Wilson refused to hear any arguments from Rusk
That's a turnaround.
as to the abolishment of mandamus. He refused to accept that mandamus had been abolished. He accepted that he had jurisdiction to hear my application. Ever since then, I've been in the Supreme Court on mandamus whenever I wish, and then the Court of Appeal after that. Now, Mr. Rusk no longer claims that mandamus has been abolished. He doesn't dare. So, anyways, I went to...
So that set a unique precedent within this troubling situation in our...
Oh yes, they
law
repealed
system.
Rule 63 right after I challenged it in the Court of Appeal, and they substituted it with Rule 4, a new rule. It says, no writ of mandamus shall be issued, but the application shall be considered, but all necessary directions shall be made by order. What they did was they just watered down the criminal conspiracy and tried to make it appear that it wasn't. If you know what you're doing, you apply for mandamus, you quote section 774 of the criminal code, and they must consider it. They cannot, if they dismiss it in the court, then there's an automatic appeal to the Court of Appeal. Now,
So this is a door that's open for everyone.
yes, this is the door that they have nailed shut.
It could be used in a situation such as yours where the officer was committing perjury on the stand.
Yes, and the Justice of the Peace refused to issue process after I brought the information and the charges. So what I did was go to the Supreme Court on mandamus to have the Justice of the Peace issue the process and start the trial process on Corporal Melky. Now, Justice Owen Flood, the one who had told me that mandamus had been abolished, well, he heard it, and he also knew my arguments in the Court of Appeal. He considered the evidence of the transcript that I had gotten from the Court of Appeal. He considered the evidence and decided that there was a prima facie case against Corporal Melky for perjury at both the preliminary hearing and at the trial. He was of the opinion that Corporal Melky should be tried for perjury. He granted my mandate application to have Corporal Melky process issued against. He ordered the Justice of the Peace to issue process. Now, subsequently, the Justice of the Peace Holmes, Allison Holmes, refused to issue the process, waiting for the Crown to instruct her. The Crown then, 3 weeks later, stayed the charges against Corporal Melky. The Crown had introduced perjury in a trial to convict me, and then after I was acquitted by the Court of Appeal, they stayed the charges against the perjurer. This is how the cakehole law system of British Columbia works. Now,
It's an ironic example.
yes, very, very. These people are a disgusting gang of criminals. They call themselves judges, lawyers. They are a mafia of the law.
Do you think that perhaps just some judges don't realize this and just they've been taught a certain way, but they're not really malevolent in their intentions?
Well, there are a lot of judges that when they become judges, they inherit it. By the time they find out what's going on, they're embedded in this criminal conspiracy like a fly in amber. They can't get out, and any struggles they make are just localized. They're insulated by all of the other conspiracy around them. The honest ones, which there are a few of them.
Such as the judge that granted you mandamus?
Yes. These judges have been waiting for somebody like me to come along for a very long time, because the lawyers of this province are programmed. They literally do not know the law. They have learned in school cakehole law. They don't even know what the criminal code says. If you go down to the courthouse now, grab a criminal lawyer, if he's not too, slimy, and ask him, what does Section 530 of the criminal code say? And they'll say, I don't know, something. They are literally taught not to see these statutes.
I mean, most lawyers are taught with omissions in the criminal code as
They are taught cakehole law. They go to school and they learn all the things the judges like and all the ways they like it. And then they come to these courts and they practice their age-old professions. They are just liars and whores. And that's their profession in the courts. Now there's another fine detail that very few people know. These court systems are illegal. Their rules are illegal. Their procedures are illegal. They are violations of the criminal code, the very statutes that were enacted to control them. Now, when you go into the courts of British Columbia, they insist that only lawyers may practice in their courts. Only lawyers may speak in their courts. Up till now, up till the present time, they have been maintaining that. In the last 2 years, I've forced my way into the Supreme Court of British Columbia. I represented a fellow, James Davis. I had a judicial decision by Justice Landers of that court that I may represent Mr. Sharp if it is not done for a fee, gain, or reward, direct or indirect, from the person for whom these acts are done. That means I can't be paid for what I do. All that I'm doing in these courts, I've done for nothing.
Yet you would be able to speak in the courtroom and
I
submit motions, cross-examination,
yes.
all the functions of a lawyer.
In the Supreme Court, they have accepted that I may speak there. I've spoken in the Supreme Court on behalf of 2 defendants. They were denied legal aid. They had no other recourse. I'm presently fighting several judges in the provincial courts who have first refused to accept that I could represent anyone in that, act as counsel for them.
Under what reasoning?
Well, you see, they're trying to resurrect cakehole law. What they're doing is saying that only lawyers have rights in courtrooms. A defendant who has a lawyer, the lawyer may speak for him in that courtroom as his counsel. If a non-lawyer acts as counsel, these judges, not all of them, are saying that the counsel cannot speak in that courtroom. He may not apply for the rights of his client in that court. A lawyer may speak to the court and apply for the rights of his clients. Most of the people who can't afford legal aid are poor and ignorant. They don't know the law. They don't know anything about it. They're completely adrift in a courtroom. And yet the judges are saying that If they have a counsel, he may not speak for them. He may not apply for applications in the court. What they're saying is that the accused has no rights in their court. Only their lawyers have rights in their courts. And this is part of an ancient criminal conspiracy where these illegal courts, with their illegal rules and their illegal procedures, have to somehow gain integrity from the accused. They have to trick the accused into giving them some legitimacy, because without the accused's consent to their illegal rules and procedures, they are illegitimate. One of the ways they do this is to convince everybody that they must have a lawyer. If you ask any lawyer, he says, if you are defending yourself in a court, you have a fool for a client. A judge will tell you, you cannot proceed in these courts without a lawyer. The fact is that when you contact with that lawyer, he is an officer of that court. As an officer of that court, he engages in a contract with you to defend you in that court or represent you in that court according to the existing rules and procedures of that court, no matter how illegal or improper. When you hire that lawyer and he appears for you, they have put the contract in place. They have tricked you into accepting their illegal rules and procedures.
This has been going on for generations.
Especially, yes, for 150 years they've been doing this and getting away with it, because very few people ever go into the courts unrepresented. You know, only the poor and the ignorant.
It's not to say that lawyers don't truly try to defend some of their clients and do their best.
Yes, but they have an unspoken agenda. These lawyers are not there for your benefit. They're there for the benefit of the court. They exist to make the courts run properly. When he's defending you in that court, he's not just trying to, overturn anything. What he's doing is making sure that the courts function. Without the contract in place between the accused and the court system, that court system is not acting lawfully. Its jurisdiction is in question. Specifically, where Section 530 of the Criminal Code is involved. In 1990, Parliament had a decision to make. The courts of British Columbia had become so criminal, the criminal conspiracies practiced in the courts by the judges, the lawyers, the Attorney General, and the law society had become so blatant that they had to do something. They could not go into British Columbia physically and start arresting, charging, and trying these judges and these lawyers. Because if they did, they would have to charge them all. And then the entire justice system in British Columbia would implode. There would be no more law left.
Who initiated this investigation?
Well, this has been known for a very long time. Now, Parliament didn't dare do that. So instead, they passed a law. They decided to take some of this out of the hands of the judges and place it in the hands of the accused, the very person who has a right, an absolute right, to defend himself in the courts. So they made this law, Section 530 of the Criminal Code. It states, upon application of the accused, whose language is one of the official languages of, that's French or English, made not before in a specific set of times, the justice of the peace or judge shall grant an order that the trial be conducted in that language. And then the companion section to Section 530, Section 530.1 states, where an application is granted under Section 530, the proceedings shall include a transcript of everything that was said in those proceedings in the official language in which it was said. This was an attempt by Parliament to create a back door for these judges to exit gracefully from the criminal conspiracy in which they were trapped,
The criminal conspiracy to do with withholding transcripts from the accused,
refusing to make the transcripts that they're required to make by law.
and thus shorts the whole process of justice moving to the appeal court and the Supreme Court of the province or Canada.
Yes, what they were doing was they were creating case law, a horrendous amount of case law on the carcasses of the poor and the ignorant. Because the poor and the ignorant could not buy these high-priced transcripts to get their appeals. So the poor and the ignorant never got any appeals.
And those cases would be used to further convict other individuals.
Yes, the procedure under cakehole law, not under statute law, not under the criminal code, but under cakehole law. These judges were trying to overcome the criminal law of Canada by a sheer avalanche of poor and ignorant people convicted. The extent of this is horrendous. The violations of 540 of the criminal code go back 100 years. That's how long they've been getting away with this. Section 530 was a direct response from Parliament. It was not just a language law. If it was just a language law, they wouldn't bother to put the transcript requirements in there. They made it very, very precise that the judge has no discretion. Upon application of the accused, the justice of the peace or judge shall grant an order. Under section 126 of the criminal code states, everyone, notice the wording, everyone, that includes judges and Prime Minister of Canada, everyone who without lawful excuse contravenes an act of Parliament by willfully doing an act that it forbids or by willfully omitting anything that it requires to be done. Sorry about that stutter there.
It's okay.
Is guilty of an indictable offense. Now this is an old law. It was in 1892 in the criminal code and existed in other statutes put out by various kings and queens.
So you're
It was
saying
meant
that
to protect us from these very judges. It says, if they willfully omit to do anything that it requires to be done, this act of Parliament, that the person who willfully omits to do it is guilty of an indictable offense. Section 540 of the criminal code stated for a very long time, the judge shall take the evidence of the witnesses under oath in the presence of the accused. He shall cause a record of the evidence to be made in legible writing on one side only of a piece of paper.
these are the transcripts.
Section 126 of the code makes the omission to do that an indictable offense. Now these judges have been very careful over the last 100 years or so to make sure that there were virtually no convictions under that section of the criminal code, because it is the section that applies to them.
So no cases, nothing, no reference.
There are only 2 cases in the entire history of that section. And one has to do with a union who didn't do something on the strike that he was supposed to do. But they have been very careful to make sure that no official is ever prosecuted under it. They have buried it so deep that nobody even knows it's there or that it can be used. It is the section that was put there for us to prosecute them when they violate our rights.
It's there in black and white in the criminal code book,
Yes.
though.
Section 126 of the criminal code, the section where judges are prosecuted. They have no immunity. That is another myth that they have put out there, that somehow they have this judicial immunity. There is no such thing. The criminal code states very clearly, everyone.
I understand. So if a judge refuses to give a defendant transcripts of his trial so he may proceed with an appeal, he is, in short, breaking the law.
Yeah, he's committing a criminal act. And his victim may file criminal charges against him.
Is that what you did in your case?
No, after my appeal and my study of law for the last 4 years now, I put all of this together. I've discovered all of the criminal conspiracies, all of the cakehole law that they've been practicing, and how illegal the whole system is. Presently, I'm representing people for nothing. I don't charge, the law says I can't. I'm overturning more law in British Columbia than all of the lawyers in British Columbia put together. The Provincial Court of British Columbia has existed for 150 years without rules of court. In 1837, King William the Just he was called, William the Lawgiver. He was one of those rare individuals, a king who looked down on these slime balls who were railroading his citizens and said, no, stop to it. He put out a statute, a royal proclamation, stating that these courts shall make rules of court for the practice, pleading, and procedure in those courts. Before then, they would just do whatever they wanted. A sheriff, if you wanted your land or your woman or something, he'd charge you with something, drag you before a JP or a magistrate. The magistrate would convict you, sometimes before even hearing evidence. They'd throw you into a dungeon, and there would be no record that you were ever there. And if some king happened to notice 10 years later that there's somebody in his dungeon and asked him why he's there, he'd say, oh, it was railroaded. And then they would say, well, where's the records? And there are no records. And then these people would take your land or your woman or whatever they were after in the first place. So people like this King William, they passed laws to protect us from these very judges, these sheriffs, the law. And that one law stated that these courts shall make rules of court for the pleading, practice, and procedure in those courts. The very same law exists today, except it says may. It says these courts may make rules of court for the pleading, practice, procedure, and all other procedures in those courts. These judges refused those rules. Poor King William, he died before he could really enforce that law. So those courts and those judges decided that they were continue on with their cakehole law, even though they were required by law to have those rules of court. Now, I was railroaded in Colwood, outside of British Victoria, by the pigs again. Now, I didn't make the mistake of having a lawyer in this trial. I went in myself. I applied for my Section 530 mandatory right. I applied to have the rules of court that this court was supposed to be proceeding under produced to me. It was only then that it became apparent that there were no rules of court. The Provincial Court of British Columbia had been operating for 150 years without the rules they were required by law to have. I did a mandamus application again to the Supreme Court of British Columbia. It was refused. It was one of the ones I've spoken about. They said they had no jurisdiction to hear it. The very mandamus that existed for that very purpose, the Supreme Court had made a rule abolishing it. That was one of the applications I made. The other one was for the Section 530. Those two were the first. The Court of Appeal application that I made after that, constitutional challenges to it, I was acquitted in Colwood without making any defense and refusing to proceed. I had told the judge that what he was doing was illegal, that he was committing criminal acts, and that I would proceed on. When the Crown had finished its case, brought its police officers and all their crap, I chewed them up, made them all look stupid, and then when it came time for the Crown to close its case, I refused to proceed. I told the judge, what you're doing is illegal.
What he was doing was?
He was proceeding without the rules of court. He was proceeding without a Section 530 case. My application for Section 530 had been refused.
Which is mandamus.
No, that's for the language of trial, for the transcripts to be there.
Oh, you applied for the language to be English.
Yes,
And thus, they must make transcripts in your chosen language.
Yes, the criminal code says that, Section 530, whichever language.
A defendant must apply for that, though. It's not automatically assumed.
If you're unrepresented in that court at your first appearance, Section 530, sub 3 states, where an accused at his first appearance is unrepresented, the justice of the peace or judge shall advise him of his right to apply for the order under Section 530, subsection 1 or subsection 2. The judges are required by law. It's a criminal offense for them not to advise an unrepresented accused right to apply for it. The courts of British Columbia have gotten around that with another cakehole law. They have a thing they call duty counsel. It's a lawyer who has to donate a certain amount of his time just to sit around in court to catch the unrepresented ones. You win unrepresented, the judge says, do you have a lawyer? And they say, no. Would you like to have a lawyer? Are you going? He says, yeah. He said, well, there's duty counsel over there. Duty counsel speaks for you. First appearance, unrepresented, and suddenly you're represented by duty counsel, and the judge then is not required
to
inform you. Now, this is just another criminal conspiracy to catch those unrepresented ones. Now, also too, when that duty counsel speaks for you in that court, again the contract is in place. They have tricked you into agreeing to their rules and their procedures, no matter how illegal they are. It's like any other contract. You sign it. It don't matter if you've read the whole thing or not. Whether you read the fine print, it don't matter. You signed it, you're bound by it. When you hire that lawyer, you've made a contract with the court system. It's a sleazy, underhanded, disgusting way to deprive us of our rights. Now this goes on and on. What's going on in those courts doesn't even remotely resemble the law as it's promulgated in the criminal code. What they have is their cakehole law and their criminal conspiracies. And they've been getting away with it all this time because people don't go into courts unrepresented. They are convinced by lawyers, by judges, by crowns, by everybody around that they must have a lawyer. Without a lawyer, you have a much better...
But you feel very intimidated in an unfriendly environment or unfamiliar environment. Everybody knows what they're doing except you.
Well, I've represented two people now in the courts. One of them is Jason Lancet. He is on my website. He is the first English person in British Columbia who has been granted an order under Section 530 of the Criminal Code. Now the history of that is, I went in at his first appearance with him, acting as counsel. Wayne Smith of that court, he was a particularly slimy type. He stated that I could not act as Jason's counsel in that court. I refused not to act as counsel. Judge Wayne ordered that I be removed from the courtroom. I refused, and several deputy sheriffs removed me from the courtroom. Mr. Jason Lancet then applied for his right under Section 530 of the Criminal Code for an order for his language at trial. Judge Wayne Smith refused. He's required by law to grant it. Without me in the courtroom, Jason was unrepresented at his first appearance with no lawyer. Subsection 1 of section 530 states, application of the accused, the justice of the peace or judge shall grant an order. The judge refused to grant the order. He then became a criminal under section 126 of the Criminal Code. He willfully omitted to do an act that was required to be done by an act of Parliament. He became a criminal at that point. The entire judicial proceedings at that point became illegal. I then proceeded with Jason to apply to the Supreme Court on mandamus for this very order under section 530 of the Criminal Code, and also for a writ of prohibition to prohibit the judge from barring me as Jason's counsel. Now, the Supreme Court, there was discussions there. They didn't really want to hear it. What they did was they agreed, the prosecutor and the judge, that it should be adjourned until after the next appearance, and that all the matters would become moot at that point. And the message was that do everything he asks, and then all this bad stuff will go away, and we won't have to face Mr. Parsons any further up in the Court of Appeal. So we went back to the next hearing, and we went in. The judge stated, "You are his counsel, you may speak for him." The prosecutor stated to the judge, "There is an order requested for section 530. I have no objection to it." The Judge K stated, "I have no objection to making the order either."
So the transcripts were provided at that point, and you were allowed to represent as well Jason.
Yes. So,
that is a first.
yes, that's the first in the history of British Columbia, and I don't know, maybe the first in Canada, I don't know.
I should say congratulations to you.
Yes, yes.
Congratulations.
But it gets even worse. After Jason here got his order, I was representing Perry Holtz. He's a friend of mine too. I've known him for 5 years or so. And we went into the court for me to represent him. Now, I stood up to represent him, and the judge said, "You can represent him, you just can't speak for him."
Okay.
They could not deny me being counsel anymore, so instead they decided to emasculate counsel. They decided that you don't have the rights of a lawyer in this court. You can
Meaning
be
the rights.
counsel, but you cannot apply for his rights in this court the way a lawyer is allowed to. They stated this to Perry. Now, I applied for an order under section 530 for Perry, and the judge refused to hear it because I was not a lawyer. Now, Perry was arrested for not signing his notice of appearance. And the fact is that the Criminal Code states very clearly, it doesn't matter whether he signs it or not. It's not an offense. But this judge wanted to punish him for having me as his counsel, because they knew what I was up to, what I was after. So anyways, they took him into custody and put him in the box. At that point, he was detained. Under the Constitution, if you are under arrest or detention, you must be allowed to retain and instruct counsel.
Of your own choosing.
Yes, it is an absolute right. A judge cannot interfere with it. They refused to allow me to be instructed by him at that point. I objected quite vigorously. There was an adjournment to the afternoon. I came back and I renewed my objections, and they ordered me out of the courtroom.
Is this today? What happened today?
No, this was
Previous.
a week ago, 2 weeks ago. So what happened was several very large deputy sheriffs physically removed me from the courtroom. I tried to glue myself to the floor, but there were too many for me. So they
They physically carried you out.
Yes. And so I said, the hell with this. I went and filed criminal charges against Judge Harvey. And I'd also filed criminal charges against Wayne Smith before that. But this Harvey, I filed criminal charges against her, against the prosecutor, and against the deputy sheriff who was present in the courtroom and prevented me from being instructed by my client, who was detained.
I see.
So it then was, we went again to the Supreme Court on mandamus, this ancient and venerable remedy. It was invented for us, to protect us from these creatures.
Ancient and venerable remedy.
Yes, it is. It's one of the few things that was really a just law. Well, anyways, we went for the hearing at the Supreme Court. A little late, we had to wait a week and a half. And so again, I stood up in the Supreme Court as I had with Jason, explained to them that I had a previous history of representing people in the Supreme Court of British Columbia. The reason that I was allowed to represent them in the Supreme Court is that I had fought my way in there on a previous occasion. Justice Owen Flood had at first had refused to allow me to speak in the Supreme Court on the behalf of James David Sharp. His explanation was that no layman may address the Supreme Court. Now, that had existed for 150 years, that principle of cakehole law, that only lawyers may address the Supreme Court of British Columbia. Now, at that hearing, I brought up the law that says that I can. The law had always been there. It was in plain sight. All these lawyers had their blinders on. They could not see that law because they had been very carefully taught not to see it. And a lot of these judges had been very carefully taught not to see the law, just to see cakehole law and not the real statute law of Canada. He stated, I would be committing an offense if I allowed you to address this court. I have the transcript of these proceedings, and if anyone is interested. Now, he stated that I would be committing an offense if I addressed his court. When I further argued against him and against the lawyer who was appearing for the Crown, whatever at that time, he got very confused and decided that maybe he'd better leave it to another judge. Now, I know the law, and I've read it all the way back to the 17th century. I know every statute. Maybe I can't quote them all word for word, but I know them, I know their meaning, I know their intent. I know what the law was originally meant to be. So he adjourned it to a hearing before Justice Landers. I presented my arguments to Justice Landers, and he stated, I am satisfied that you can appear for Mr. Sharp if you're not doing it for a fee. That was a judicial decision that David Alexander Parsons is the first layman in the history of British Columbia to address the Supreme Court of British Columbia. It was a precedent, I guess you call it.
Precedent, a first, another first.
Yes. These ancient cakehole procedures have been following like dominoes, simply because I'm not a lawyer. I can go into those courts and do things that lawyers can't do. Anyways, now I address the Supreme Court. They can't lock me out. They had the doors firmly locked, bolted, and nailed shut before I came along. And I kicked them open. They're available for anyone else to go in now. Further, when I did my constitutional challenge in the Court of Appeal against the provincial court, when my appeal was dismissed because I'd been acquitted and no longer in jeopardy, within a year, the provincial court of British Columbia made the very rules that I was demanding that they make. For the first time in 150 years, the provincial court of British Columbia had legal rules of court.
Are those rules written down anywhere where someone may look, or are they posted
Yes.
on your website?
They are posted on my website. The government posts them, but they're very hard to find. The government has to know the real rules. So these cakehole law procedures have been falling over like dominoes simply because I got up and took a kick at them.
Persistently kicking at them.
Nobody's done this
So
before.
if you got something to say to the people out there who wish to defend themselves or get counsel from a layman, what would you say to them?
Read my website.
And your website is?
Yes. Cakehole law. Canadian criminal injustice system and how yourself. Just put in a search engine, put cakehole law. And then it will bring up a number of links. You click on them and they'll take you to my website or to another link that will take you to
And
my
you have
website.
documentation there, and it's being updated as this fight
Oh.
continues.
All my arguments, all my motions to the courts, all my affidavits, they're all there. Everything you need to know is there.
Could some of you also
Oh yeah,
from your site?
yeah, I have, my email is there, WAO96 at victoria.tc.ca.
Okay, well, thank you very much, David. And I'm
Okay,
sure all the people of Canada will eventually thank you too. So we're out of tape, out of battery.
Well, thanks very much. That was a lot of effort for you.
Right on, you're great. You show up
Good.
really
Wow.
good.
Well, we hit the 4 gig limit.
Did we?
Yeah, we did quite a while ago actually.
And it went past it?
It didn't.
Oh yeah, it just.
So we lost about. We only got about half of it, but
That's okay. We can join it. It's on the tape. We can
it's
join it up
crunching it
later.
down right now with the MPEG 4, which is the really
Oh,
new
good.
high.
We can put it on
resolution.
CD and archive it.
Yeah.
yeah, and maybe get some hope to some of those people out there because there are thousands and thousands of people in jail.
I know when you actually said that, it's built on the cases of the poor people. They say, oh well, in this case, such and such. So they just use that to charge another person.
Yeah, they just pile it as deep as they can. And guess what? In all those cases where they don't give them no jail time, that's where they're building their case law. Because legal aid will not fund an appeal if there's no jail time. So they give you a suspension.